A major case is now unfolding at the Supreme Court that could have a huge impact on the future of the National Firearms Act and its restrictions on short-barreled rifles. The court has recently taken interest in this challenge and has ordered the Trump Department of Justice to respond. That move alone signals how serious the justices are about reviewing this issue. On top of that, multiple Second Amendment organizations have stepped forward in strong support of striking down the NFA's restrictions. This makes the case even more significant. The case is titled U.S. v. Robinson, and it directly challenges the constitutionality of the NFA's rules on short-barreled rifles. In his petition, Robinson is asking the Supreme Court to declare that these restrictions violate the Second Amendment. This case had already been heard by the 11th Circuit Court of Appeals, which upheld Robinson's conviction. But now, the Supreme Court has been asked to review that decision and ultimately strike down the NFA restrictions. Originally, the Trump DOJ waived its right to reply to the petition. The court, however, wasn't satisfied with that. In a rare move, the justices issued an order requiring the DOJ to file a formal response. That means the DOJ must now directly address the constitutional questions raised in this case, which is very encouraging news for the challenge. Even more encouraging is the fact that several major 2A organizations have already filed briefs supporting Robinson and pushing the court to strike down these restrictions. Now let's look at the facts of this case. On September 9, 2022, law enforcement officers responded to a report of a suspicious vehicle parked outside a home in Florida. When they arrived, they found Mr. Robinson asleep inside his car. As officers shined a light into the vehicle, they noticed a rifle along with a buttstock. After searching the vehicle, they discovered a loaded short-barreled rifle and a separate upper receiver with a 16-inch barrel. The short-barreled rifle, however, was fully assembled and ready to fire. After officers recovered the short-barreled rifle, they checked the National Firearms registration and transfer record. That search revealed the rifle was not registered under the NFA. Because of this, Robinson was charged with violating the NFA for possessing an unregistered SBR. He was later tried in a bench trial, convicted, and sentenced to 18 months of probation along with 6 months of house arrest. Robinson appealed his conviction to the 11th Circuit Court of Appeals. In his appeal, he argued that both the statute itself and his conviction violated the Second Amendment, especially in light of the Supreme Court's decision in New York State Rifle and Amp Pistol Association v. Bruin. Robinson claimed there was no text, history, or tradition that supported the NFA's taxation and registration scheme. The 11th Circuit, however, rejected all of his arguments. The court ruled that the NFA does not violate the Second Amendment and upheld the law as constitutional. They went even further, stating that the NFA operates as a valid tax. On the Second Amendment issue, the court relied heavily on the Supreme Court's old Miller decision. In that case, the court had ruled that short-barreled shotguns were dangerous and unusual weapons and therefore could be restricted. The 11th Circuit concluded that there was no real difference between short-barreled shotguns and short-barreled rifles. Because of that, they treated Miller as binding precedent and applied it to SBRs. According to the 11th Circuit, until the Supreme Court changes or clarifies its stance, Miller controls the issue. The court also dismissed Robinson's tax argument. They pointed to the Bruin decision, saying that Bruin left room for certain objective requirements, like background checks, fees, and even some taxes, under the Second Amendment. Using that reasoning, the court ruled that challenges to the NFA based on taxation would not stand. That brings us to where the case is now. This ruling is being reviewed by the Supreme Court, and the justices have been asked to answer 2 critical questions. First, does criminal punishment for possessing an unregistered short-barreled rifle violate the Second Amendment? And second, does punishing someone under the NFA for possession of an unregistered SBR go beyond Congress's taxing authority under Article 1, Section 8 of the Constitution? In his petition, Robinson pushes back strongly against the idea that Miller settled the question of whether SBRs are protected arms. He argues that SBRs are indeed protected under the Second Amendment. Under Bruin, He says the federal government must prove that there is clear historical and traditional support for imposing this kind of registration and taxation scheme. Robinson insists no such history or tradition exists, and therefore, the NFA's restrictions cannot stand. Recently, as I mentioned earlier, the Trump DOJ initially filed a waiver, indicating they would not be responding to the petition in this case. However, the Supreme Court stepped in and ordered the DOJ to file a response. After being granted an extension, that response is now due on October 20th. Another significant development is that several major Second Amendment organizations have come forward in support of Mr. Robinson. Gun Owners of America, along with other groups, filed an amicus brief urging the Supreme Court to hear this case and strike down the NFA's restrictions as they apply to short-barreled rifles. In that amicus brief, these organizations argue that the founders would never have accepted a system where an otherwise law-abiding citizen could be turned into a felon simply because the barrel of his rifle was a few inches shorter than an arbitrary government standard. Yet that is exactly what has happened here. A felony conviction for possessing an unregistered short-barreled rifle under the NFA. Now, the NFA does not outright ban these rifles, but it heavily restricts them through taxation and registration. What makes this so troubling is that this tax applies only to Americans exercising a constitutionally protected right. In other areas of law, the Supreme Court has made it clear that such targeted taxes are unconstitutional. Supporters of Mr. Robinson argue that the court's involvement is needed to correct the mistakes being made in the lower courts and to settle this issue once and for all. This is a very important development because not only has the Supreme Court forced the DOJ to respond, but this is now the second major challenge involving the NFA and short-barreled rifles to reach the court. It's also the second time the justices have ordered the Trump DOJ to file a response. The fact that the court is demanding answers shows that they are taking this issue seriously. Adding to the weight of this case is the recent legislative change under the One Big Beautiful Bill, which reduced the long-standing $200 NFA tax to zero. That creates a very unusual situation, one that could encourage the court to step in and address whether these restrictions can continue to stand. So right now we are waiting for the Trump DOJ's response, which is due on October 20th. With multiple organizations backing Mr. Robinson and strong arguments being made against the NFA's restrictions, this case is shaping up to be one of the most important Second Amendment battles in years. As this develops, I'll continue to keep you updated here on the channel. If you found this breakdown helpful and want to support the work, the best way is to subscribe. As always, thank you so much for watching and for your continued support.